Chairman, Ranking Member, members of the committee. This bill intervenes in private contracts to ban informed, competent adults from agreeing on the process they'll use to resolve future disputes. It restricts freedom. It diminishes the freedom of Americans to make contracts. The Democrats seek to demonize arbitration agreements with misleading rhetoric. An arbitration agreement is simply two parties agreeing in advance on the best means of resolving a future dispute between them should one arise, and to make that decision part of the ground rules of their bargain. The bill uses the term forced arbitration, but to the point of the subcommittee chairman, these agreements, these provisions are explicit. They're in the contract that is signed or agreed to. They're not hidden. It just requires reading the contract. There's nothing that forces a person to agree to an arbitration clause that doesn't apply equally to the rest of the contract. And truly forced or involuntary agreements are already illegal under existing law. Democrats want to invalidate pre-dispute arbitration agreements to force more people into court for prolonged battles that serve only the interests of plaintiffs' lawyers, particularly plaintiffs' class action lawyers. They paint agreements to arbitrate as inherently unfair, as if no one would ever willingly agree to use arbitration, but that's simply false. Arbitration is often more efficient and faster than going to court, meaning that injured parties are made whole faster than they would be if they filed a lawsuit. Studies show that plaintiffs in employment and consumer disputes win more often in arbitration, and they get more money than they would in court. Even though arbitration may be more attractive than going to court for several reasons, Democrats dismiss those benefits, again, with misleading rhetoric. They say if arbitration is so beneficial, parties can agree to arbitrate after a dispute arises. Of course, that's nearly impossible after tempers have arisen. That's not the time to agree on a dispute resolution process, nor is it the time to evaluate the costs of such a process and how it would affect the bargain the parties have entered into. Once you're in a dispute, you often have legal counsel who have their own motivations with respect to litigating at length. We know that lawyers do have a financial incentive to recommend the most time-consuming, legally complex, and expensive course of action, meaning litigation. By forcing parties to consider arbitration only after a dispute comes up, the bill will effectively take the option to arbitrate off the table. So this will mean more Americans will spend more time in court, pay more in attorney's fees, likely get less money in return. In addition, they'll bog down the court systems, both federal and state, under an extraordinary burden, making the resolution in those forums even lengthier. That's the future for Americans who can afford to go to court with their dispute. And some Americans simply won't be able to afford that litigation. They won't have their claims heard at all. Job creators will feel the effects as well. Because litigation is more expensive, the bill will raise the cost for American small businesses. Employers are already dealing with through-the-roof inflation and a supply chain crisis. This is another distortion of the ability to supply goods and services imposed through federal regulation. With higher litigation costs piled on, they'll have to raise prices and hire fewer employees. Big companies have the cash to hire fancy law firms to defend lawsuits. Smaller businesses that I served in the course of a 30-year litigation career often do not. More lawsuits surely won't help everyday Americans or small businesses, but they will help plaintiffs' lawyers, especially those lawyers who make millions from class action lawsuits. You know, the ones in which consumers get a $5 coupon and the lawyers buy a new jet. It's no surprise that Democrats have been pushing this attack on arbitration agreements for years, particularly recent years in which there have been a series of Supreme Court decisions that specifically limit the ability to bring those class action lawsuits through arbitration. So it's telling that Democrats have consistently, and they do in this bill again, carve out agreements to arbitrate for unions in union contracts. If arbitration is as bad as they say, why is that carve-out there? And the bill is not limited to future contracts that parties will make from the point this bill is passed onward. It voids millions of contracts that now exist, contracts that are now completely legal and that were entered into on the basis of a bargain that included an arbitration agreement. The economy of the United States is the envy of the world, in significant part because our contract law provides certainty. Our rule of law applied to contracts allows bargainers and deals to plan. And this bill threatens to erode this fundamental feature of our law. No matter what you think about pre-dispute arbitration agreements, everybody should be alarmed when the federal government sets out unilaterally to rewrite private contracts and tell Americans what they cannot agree to. The bill micromanages private relationships and puts the priorities of the plaintiff's bar and union bosses above the interest of hardworking Americans and small businesses. As I said, I practiced law for almost 30 years, representing plaintiffs and defendants in litigation and in arbitration. The first ever appeal that I filed in a case called Benish versus North Carolina Dance Theater was from a trial court decision refusing to enforce an arbitration agreement. A dancer for a professional ballet company sued over the termination of his employment. And this wasn't a wealthy Amazon-sized corporation oppressing employees, but a fledgling arts organization on a shoestring budget struggling to survive. I worked in that case for free. This bill would have forced that dispute to court and destroyed that arts organization. The bill's overbroad. It's destructive, not only of Americans' freedom, but also of court system dockets. It's an exercise in impracticality, mostly for the sake not of disputes like the one I just made reference to that affect ordinary Americans and small American businesses across the country day in, day out, but mostly for the sake of the plaintiff's class action trial bar. It's a bad bill. And for these reasons, I urge my colleagues to oppose H.R. 963.